Risk, liabilities, indemnities, and insurances are extremely complex in construction contract, particularly if the size and cost of the project increases. Although wording of the clauses are very simple in 4th edition FIDIC 1987 version, however, it remains complex for engineers as it covers legal and insurance topics in which engineers of course are not experts. So today we will discuss risk, responsibility, liability, indemnity and insurance under Red Book 1987 version. This will be our 8 lecture part 1. Provision under Red Book 1987 versions are class 20, 21, 22, 23, 24, 25 and 60 class 65. These are a relevant provision under Red Book 1987 version. Class 20 is divided into 4 subclasses. Class 20.1 is care of works, 20.2 responsibility to rectify loss or damages, Class 20.3 loss or damages due to employer risk, Class 20.4 employer's risk. For sake of understanding, we will discuss Class 20 in following manner. We will discuss Class 20.4 employer risk at second number. At first, we will discuss Class 20.1 care of works. Under this provision, contractor is responsible for care of works, plants to be incorporated in works, and material. This responsibility will commence from the date of commencement until date of issuance of taking our certificate. After that, this responsibility will pass to the employer. However, the contractor shall remain responsible for care of outstanding works which he will undertake to complete during defect liability period. Now we will discuss class 20.4 employer risk. Employer risk includes war, hostilities, invasion, act of foreign enemies, revolution, insurrection or military or usurp power or civil war. Usurp means take a position of power or importance illegally or by force. Third is ionization, radiation or contamination by radioactivity from any nuclear fuel or from any nuclear waste from the combustion of nuclear fuel. Radioactive, toxic, explosive or other hazardous properties of any explosive nuclear assembly or nuclear component thereof. Pressure waves caused by aircraft or other aerial devices traveling at sonic or supersonic speeds. Rights, commotion or disorder. This is very important. Rights, commotion or order is the employer risk. However, there is a exception is available if the rights, commotion or disorder is due to a contractor or his subcontractors employees. This will not be a employer risk. Loss or damage due to use or occupation by the employer of any section or part of the permanent works, except as may be provided for in the contract. If employer take possession or occupation of any part of the works or whole works, if any loss or damages occurs due to employer's that occupation, this loss will be employer risk. This is very important. Loss or damage to the extent that it is due to design of the works other than any part of design provided by the contractor or for which the contractor is responsible. Design is the employer risk. However, if the design is provided by the contractor for which he is responsible, that will be not the risk of the employer. The last is any operation of force of nature against which an experienced contractor could not reasonably have been expected to take the precautions. Now we will discuss subclass 20.2 responsibility to rectify loss or damage. For sake of understanding, this class may be subdivided into two parts. First one is from the date of commencement till date of issuance of TOC. Second is operation during defect liability period. If loss or damage happens to works or any part thereof, materials for incorporation therein, plants for incorporation therein, during the period for which contractor is responsible for care thereof, the contractor shall at his own cost rectify such loss or damages. The contractor shall be responsible if any loss or damage happens to works, material or plants during the period for which contractor is responsible, and contractor shall rectify such losses or damages at his own cost. The contractor shall also be responsible for loss damage happens to works during any operation carried out by the contractor in compliance of his obligation during defect liability period. So, in simple words, the contractor shall be responsible for loss or damage happens to works from the commencement date until date of works taken over by employer for any outstanding works which the contractor undertakes to complete during defect liability period. Now we will discuss class 20.3 loss or damage due to employer risk. If any loss or damage happens from employer risk or combination with other risk, the contractor, if required by the engineer, rectify such loss. The engineer shall determine the cost with respect to proportional responsibility of the contractor and employer.